here to discuss a sensitive subject we all need to talk and think about. Here now is Jennifer Graziano and Time to Talk.
Good afternoon, Westchester. It's 12 noon on Wednesday, and that means it's time to talk with me, Jen Graziano. I'm a licensed funeral director who oversees my family's funeral homes, Cox and Graziano of both the Mamaroneck and Greenwich, and the Zion Memorial Chapel of Westchester. Every Wednesday, I come to you discussing important topics and sensitive matters that all of us need to pause and reflect upon at some point, and through this show, I hope to provide a platform to do so. If you are joining us on air at 1460 WVOX, we welcome questions, comments, and calls to 914-636-0110. And hello to my friend Gerald in the control room. And good afternoon, Facebook Live viewers. Thank you for joining us. And thank you to Tim Judge behind the camera. So, I am joined today by a repeat guest. He's probably the most frequent guest I've had on over the past 3 years. I don't want to give him a big head or anything, but I am speaking with Sal DiCostanzo, an elder lawyer with offices both northern and southern Westchester. So no matter where you are, he's there to answer a question. He's a partner and maker for Fragale and Di Costanzo, and we're talking about something that came up the other night when I was giving a class to attorneys at the New York City Bar Association. It struck me that the amount of attorneys who weren't really comfortable with the subject matter and didn't have all the answers made me think, wow, if they don't know it, who else doesn't know it? And this is really, really important information. So I brought Sal on because he is our resident legal expert on Time to Talk. And we're going to be talking about important conversations that you need to have with family members that are arguably extremely uncomfortable, but you need to have them, and Sal's going to help us break down why. So, hi Sal, good afternoon.
Good afternoon, Jen. It's always good to see you.
An attorney, an accountant, 4 days before a tax deadline. Now I feel bad that I brought you on air. We're almost there, so we'll get you out in 27 minutes now, so it's all good. So, Sal, there's so many misconceptions that I get in my line of work. I can only imagine when people come into you, when clients come into you. There have to be so many misconceptions that you help to clarify. Let's start with something that comes up very regularly in my job. Let's talk about common law marriage, which is not recognized anymore.
It's not recognized anymore.
So talk to me about clients who come to you. Let's say they've cohabitated for 25 or more years. They love each other deeply, but for whatever reason, they never made it official. A million euphemisms I can give to that, but we're just gonna keep it there, keep it clean. They never got married. Talk about issues that can arise from that, be it beneficiary status, which I know you can designate anyone, but Medicaid purposes, estate planning purposes, and then we'll get down to funerals.
There's a whole host of issues that come up with that. I mean, at its basic level, there's a misconception out there that because you're married, that you have rights. That because you're living with somebody, you have rights.
I was going to say you do kind of have rights when you're married, Sal. But
similar to the people that are married.
Right.
So we do see these instances where people have been living together for quite some time in a relationship. They're not legally married, and they don't share the same inheritance rights as a spouse would. It might be important to maybe review just real quickly under New York State law what those rights sound like.
That's why we're...
absent a will, we're not talking about people that actually have a last will and testament. Most of the situations that we see, people haven't taken the time to properly draft. Mm-hmm. But if you live in New York State and you don't have a last will and testament, there's an actual statute that provides a boilerplate will.
Right.
And that statute reads pretty much as follows. If you're married, your assets would go to your spouse. If you're married with kids, believe it or not, your assets get split in certain fractions between your spouse and your children.
Now, there's an elective share in New York that you cannot disinherit a legal spouse, correct?
That's right. All this is subject to the elective share. And for our listeners that don't understand what an elective share is, you cannot disinherit a spouse in New York State. A spouse in New York State is allowed to receive statutorily a certain amount of assets from their deceased spouse.
And it's like a flat fee plus 1/3 of the entirety of the estate?
Yeah, it's
Like
pretty much like
50,000 plus
50,000
one-third?
plus one-third
Yeah.
of the estate. The greater of $50,000.
Okay.
So it usually ends up being one-third.
Mm-hmm.
And a lot of people are surprised as to what goes into that calculation, because there are ways to defeat the right of election. There are certain assets that are not counted towards the elective share.
So again, and nowadays too, where insurance companies and employers do recognize non-marital parties for insurance coverage purposes. Like for example, if you're living with somebody, there are cases where you might be able to put them on your health care plan. And I think that also works towards this misconception where people think rights exist where they do not. What about being on the domestic registry? Does that qualify you as arguably a spouse in New York State?
That, as far as I'm aware, it does not.
Okay.
We had a case recently where we looked into that, and domestic partners were not legally married.
Okay.
And so they were not afforded the same rights, inheritance rights, that we would see with a traditional couple.
Now, in our case, in terms of funeral planning, one of the biggest issues we face is who can actually come and speak to the funeral director, sign authorizations, especially for cremation. So New York has created this document, which we refer to as an agent letter. In short, you and I have worked on this, and we've talked about it. This is for people who, there's a legal hierarchy of who can plan your funeral. And on top of that list is your spouse. And for this purpose, a domestic partner on the domestic registry, so a registered domestic partner can act in the capacity as a spouse. There will be equal recognition to that.
So it's actually interesting because on one hand, we're talking about the rights that individuals have that are not married, just living together. And there's a lot of misconceptions as to what those rights may be. But there's also a tremendous amount of misconception for people that are married. A lot of people think that because they are married, because they have legal rights under New York state law, that those rights expand really without any barriers. So, for instance, to your point, I can't sign your name if you and I were married. I can't sign your name to the deed to our house.
I should hope not.
But you'd be surprised. People come in on a regular basis and they say, "Well, why do I need a power of attorney? We're married."
Right.
Well, just because you're married doesn't mean that you can act on behalf of your spouse for all matters.
And then I think this also starts leading us down a different road. And I touched on it this morning with Bob on the morning show when we were promoting the show. There's a lot of, probably with your older clients, but there's a lot of situations where one spouse is generally left in the dark. And oftentimes, in the typical situation, couples that have been married 50, 60 years, the husband was the breadwinner, the wife took care of the house and the children, which was it is a very important role that cannot be underscored. However, as a result of that, they're often left in a legal and financial darkness. So communication, I feel, is so important, because what happens in situations where that male spouse passes away, there is, there's an absolute education that needs to be had in a very short window of time for that surviving spouse.
This comes up in our practice all the time, and it's actually a pitch for the financial advisors. If you can align yourself with a quality financial advisor, somebody that really is going to plan with you, and maybe is not so focused on the returns, but more of the overall picture. I'm regularly advising my clients to align with a good financial planner, so that way that transition is easier when one spouse dies. Because you see that often, where one spouse, and it doesn't always have to be the husband or the wife, but you see often where one person has no clue what the finances are.
Absolutely. So again, we're talking today about conversations and having really important conversations. Now, going back to the non-married parties, and, companionship is a thing. When you take situations of, perhaps widows and widowers who, they lose their spouse and then they find love again, but they don't want to get married because at this point they have separate finances, separate assets. They each have their respective heirs and assigns and children. But they have cohabitated for 10 to 15 years. Conversations there really need to be had because, again, if one of them gets sick, it's that other party living with them who's likely going to get charged with the duty of care. But without any documentation, you're not just going to be able to go into the hospital and act on their behalf or make decisions, medical decisions. or be privy to healthcare information.
Right.
So how important is talking between people who are in the scenario we're discussing?
It's extremely important. We see this in second marriages often. One of the cases that I'm working on right now, it's a relationship now that is developed over years. Both parties were married, had prior marriages, and now they're living together. And the wife owns the house.
Okay.
She came into this new relationship with the house, but they've been living there for 20 years.
In that house?
In this house.
Okay.
And now the question is, well, if the wife dies,
what rights does he have to remain in the house?
And so we have to be very careful when we draft the documents, because you have competing interests now between the children of the prior marriage,
right,
and the domestic partner, if you would, who's been living there for the last 20 years.
Are there rights in a case like that, Sal? If a person's been living in a residence for, let's say, 20 years or 10 years, does some type of habitual right kick in? Or not right, but...
I'm not going to purport to know the answer to that question. Right. I think that's more of a real estate question. Okay. I don't have an answer to that.
Or even, I'm sure, it's a case-by-case, too. It's,
I think the better way to handle that is to draft the documents properly. So when we're sitting down to draft these documents, we're providing some sort of life estate to the surviving, partner. But it runs afoul of maybe what the kids think they're about to inherit. They may not have the same relationship with that person that their mother had, and now they've got to wait an extended period of time to monetize their inheritance.
Right.
And this may sound like it's all about money, but it is.
Right, and human nature is a real thing.
That's
and
right.
I think that, if being honest and having real conversations, you have to take into account the feelings and the sentiment. I always say, who really likes a second wife, right? I mean, there are great cases where it works out, but, there's emotions tied to, especially if you have a case where, the biological parent passed away, and then you didn't like to see the other person come in, or if there was a bitter divorce, and then, mom never moved on, dad did, and there's all of these emotions that are very real and very understandable, but they cloud judgment.
That's right.
And they cloud the ability to make rational decisions. So the way to avoid these conflicts is to have this uncomfortable talk during your lifetime.
It's very uncomfortable.
Yeah, okay, listen. All right, kids. So I've been with Susan for 10 years, and I know she's not your mom, but Susan's going to get X. And then this is going to help Susan down the road, and then it's going to help your kids because there's going to be an awareness.
That's right.
In terms of Medicaid, Sal,
Well, that's really where the rubber hits the road.
I was going to say. I mean, is there any allotment for anything for this non-married party?
It depends on how they see the family unit. So
really? It's that subjective?
Yeah, well, because our traditional Medicaid planning techniques, like a Medicaid trust, if there are children of prior marriages, it's sometimes often very difficult to provide for the wishes of the parents, also provide for the surviving spouse, which is not the parent of the children that ultimately are the beneficiaries of your estate.
Right.
So it becomes like this triangle. We have a case going on right now, and a lot of this is often not, you can't really plan for some of these things because you don't know when people are going to get sick.
Right.
Right. A traditional Medicaid planning technique between husband and wife is to just take the assets and transfer them to the well spouse.
Correct.
So if husband goes into a nursing home, if we've got the right powers under a power of attorney, we just move the assets to the well spouse's name, and that's called spousal refusal. We do that all the time. Well, now, if I don't have a marriage between two individuals, I don't have spousal refusal. But if it's a home care case, there's no 5-year look-back period. So we can actually move the assets to that partner. But now that partner has a completely different estate plan.
Absolutely.
Than what the incapacitated person might have.
And then you can really see the family issues because, if there are surviving children there.
There's no guarantee that I can honor the wishes.
Right. And, the thought of just transferring home and assets to a non-married party with no legal interest, I mean, I can understand why that
And we're on the brink of litigation in this one case right now where it's exactly that fact pattern.
Really?
Yeah.
So, I mean, again, this is real. So all of the hypotheticals that we're posing today, they're not just what ifs.
No, I'm speaking about a real fact pattern where the children, there's a woman who has dementia, and she's been being taken care of by her spouse.
A legal spouse, a real spouse.
Yes.
Okay.
And the assets, we want to move the assets to the well spouse. but he's not the father of her children, and the children don't see eye to eye, and they're raising a lot of issues and concerns as to the viability of these transfers, even though they're allowed under the law. And we may do these transfers or make these transfers, but we might end up in a guardianship proceeding.
Let's talk about that. Let's talk about guardianship proceedings. And is it common in a case like this where there's an actual spouse, but it's a second spouse, and let's say the children are not seeing eye to eye? Is there any standing or ground to apply for guardianship when there is in fact a present spouse?
Yeah, I mean, but you got to remember the fundamental tenet of guardianship is that the person has functional limitations.
Okay.
And must be in need of a guardian. In other words, you have to have functional limitations, and you don't have an appreciation for the harm that you may cause yourself because of those functional limitations.
Okay.
So just because the kids aren't getting along, we don't really just want to commence a guardianship.
Right, and there's no, are there any grounds if you feel that there's an irreparable financial harm, like if they're not, if they're not mindful of money, or if they feel the other spouse is perhaps, taking money or mishandling, misappropriating funds?
Yeah. So we did that last year. We commenced the guardianship proceeding. This was a case where they were not married.
Okay.
This is it's intriguing that you asked me to come speak about this today, because this has been coming up over and over again. But last year we commenced the guardianship proceeding where the son-in-law. So there was a mom.
Okay.
Her daughter was married to this gentleman.
Okay.
And they got divorced. And after they got divorced,
the daughter and son-in-law.
Yes.
Okay.
And after they got divorced, the son-in-law stayed in the house with mom and developed a relationship with mom.
How convenient.
And from there on, began to pilfer assets, misappropriate funds, develop a trust factor. And the kids came to us and asked us to commence a guardianship proceeding because mom had functional limitations, could not appreciate what was going on,
right?
The duress and influence,
right.
etc.
Right.
And we brought a guardianship proceeding, and we were able to get back a lot of the assets that were misappropriated. Oh, wow. We had to provide for what living arrangements he had, if any, all through the guardianship part.
There, and the reason this is so prevalent because the nuclear family is kind of gone, if you think about it. It's very, divorce rates are high, opens the door for subsequent marriages. People remarry after the death of a spouse. It's very real. I mean, I have, even in my experience, again, now it's getting back to control funerals, I had a case very recently where a woman came to us. She was not a legal wife. She must have been with him about 20 years. She had a minor child with him, 16, and the man passes away in a car accident on the South Carolina state line. There was even a question as to what state this occurred in. It was so complex. So automatically, your legal background kicks in and okay, I understand she's a minor, but 16 is certainly the age of reason. Let me get permission from her. And the poor girl was involved in the accident with the father who passed. So we obtain the necessary authorizations that allow us to speak to the non-married companion. And then the day of the wake, somebody shows up and says, I'm his daughter. And she was clearly in her late 20s. She was the adult child, and she wasn't brought up to us. And this is not that, as crazy as it sounds, it's not uncommon.
Nope.
It's not. Somebody called me the other day and said, well, we're together 24 years. And that, obviously, there's an emotional weight to that. There's an emotional significance. But in terms of signing papers or the proper authority to give instruction, it's just not there. So we hope what you're taking away from this is if you are cohabitating or you have a long-term companion, that's wonderful. That's a great thing to have. But you have to be mindful of the legal issues that can arise and address them now while you can. Because like Sal is saying, these are very common scenarios. They sound outrageous, but it's happening more and more. So if you're listening or if you're watching and this sounds like you or it sounds like it could potentially be you, have conversations now and also align yourself with a very good elder law attorney. And we're going to transition into that now. Because the issues that you're speaking of today, guardianship, you mentioned look-back periods, we're talking about power of attorney, healthcare proxies. These are all issues that arise as we age. Not just any lawyer can do this, folks. This is not, you know, the general physician, the internist that you can go to if you have a headache or stomach ache. You need a specialty here because there's too much on the line. There are tangible assets on the line, a lifetime of accumulated wealth, and if not done properly, you and your family could stand to lose a lot of what you've worked your lifetime to grow. Talk about that, Sal, about the people who come to you without a plan, or they say they've been to a lawyer before and they show you what was done.
Yeah, a lot of times, you know, what I'm seeing are very basic documents, and it's very difficult sometimes to explain to people why they need more complicated documents.
Mm-hmm.
But all these issues that we're talking about, you know, the way you address these issues is by properly crafting your documents. So when we draft wills, and you don't see this often, we draft a lot of definitions. We control our documents by using definitions. I could define who your children are. Right, and you often never see that. So if you have a child born out of wedlock and you want to include that child, I can define who your children are in the document and let your document read that way. I could also do the reverse. I've often prepared documents where you know, people have come to me and they say, you know, I'd like to meet with you separately. I've got something to tell you, and they tell me about children that were born years and years ago.
Right. Or situations too where, you know, a second marriage comes in and they adopt the other party's child, or maybe they didn't go through that legal proceeding, but they certainly loved and cared for the child as if they were their own.
That's right.
And definitions are so important.
All. I mean, it's not, you know, everybody doesn't need this.
Right.
But you'd be surprised how often some of these very subtle issues need to be addressed in the drafting of the document.
Sal, talk a bit about powers of attorney. What in fact they are, what are they used for, who are the most common players?
You know, I sound like a broken record on powers of attorney. It is the most powerful document, no pun intended.
Okay.
People come into my office and they say, I want to get my affairs in order. And I'll say, what does that mean to you? And they'll say, well, I want to draft a will. And then I'll explain to them, do you understand that the will takes effect when you die?
Right.
Doesn't help you while you're alive.
Right.
And people don't really understand what I mean by that, but the power of attorney is that document where if you lose your capacity, you're still alive. You lose your capacity, somebody can step into your shoes and handle your affairs.
Right.
Like the deed to the house, changing beneficiary designations, making funeral arrangements.
But when you actually pass away, though, that power of attorney ceases.
It dies with you.
And that's another common misconception.
It's
People
a misconception.
will come to me and say, well, I was a power of attorney. That doesn't matter now. You can kick in as another status now.
That's
you can
right.
be the closest person to the estate or a fiduciary of the estate, or, you know, you could be under a different catch-all. But again, that purpose is during your lifetime, and it can be a durable or have a limited scope, correct?
Yeah, we don't really see the limited scope anymore.
Okay.
In 2009, the law was changed.
Okay.
And we really just use durable powers of attorney now.
And now that can survive incompetence,
Incapacity.
correct? Okay.
Yeah.
All right. So, again, is it common for spouses to have this on each other, or
Yeah,
adult children
it's
to have
common
it?
for spouses, but what really needs to be done is you can't just take a boilerplate form.
Okay.
And
Like the
reason-
LegalZoom.
Yeah,
We the
LegalZoom
people document, right.
or you know, even a general practitioner attorney, people that are getting these forms handed to them by title companies,
Mm-hmm.
etc. The basic form does not have the proper powers in it, and a lot of people don't realize that.
So what is it missing? Explain that.
Gift-giving provisions.
Okay.
The standard power of attorney doesn't allow you to make more than $500 in gifts.
Okay.
So if we want to do Medicaid planning, if we want to set up a trust, if we want to move assets out of your name, I need to modify that power of attorney.
Okay.
I need to attach a statutory gifts rider to the power of attorney and then provide unlimited gift-giving powers.
Okay.
Not only unlimited gift-giving powers, but powers for the agent to make gifts to himself or herself. Because often it's a spouse saying, let me move my spouse's assets.
And
to
that's
me.
all permitted. You can
It's all
you can be
permitted.
that power of attorney. You can have
It's all permitted.
self-directed transfers.
Yep.
Okay.
But if it's not in writing,
Okay.
it's not permitted.
Okay. You know, even cases, you know, if you're traveling and you're out of the country or you're away, or let's say there's adult children or one
Mm-hmm.
specific child. If you have multiple children and you have one child that kind of knows the ins and outs of your affairs, you know, this is important too, because this is kind of a vehicle with feuding children, I would say, correct?
Yep. And I'll take it one step further. I've got kids who go to college. Everybody wants to know, well, what age should I be before I start doing this? Well, how about a kid that's going to college? parties, sporting events. Anything can happen to anybody at any time.
Okay, yeah. So you're suggesting that even at the college age,
That's right.
you have a power of attorney drafted on yourself.
I wrote a blog about that last year. You know, when kids are getting ready to go away to college, they should come into our office and draft a power of attorney in a healthcare proxy.
Wow, and in light of all the crazy things you hear on college campuses, Sal, that makes so much sense, and I would have never thought of it. This is why you're our legal expert. So you do blog frequently on all of these topics.
Twice a month.
Twice a month. I think everyone should go to Sal's website and read, because it's a great education. And make an appointment with him. Again, no matter where you are in Westchester, you can get to him quickly. What is your email address, your website?
PlanTodayForTomorrow.com. All
Even
spelled
catchy. PlanTodayForTomorrow.com. Sal DiCostanzo, maker Fragale and DiCostanzo, an expert in the field of elder law and planning. It's never too late to start your plans, folks. So be wise. Call Sal. This is Jen Graziano thanking you for taking the time to listen as we took the time to talk. Have a great day, Westchester. Bye-bye.